Hi folks, HR Funk here. From time to time, I'm asked by viewers to give my opinion on legal issues related to the defensive use of firearms. And historically, I've avoided that topic for a couple of reasons, one of which is that laws differ from state to state and jurisdiction to jurisdiction, and I would not want to give someone my opinion on something and have them follow that as advice only to find out that the laws are different where they live and they get into some kind of trouble for doing what I told them they should be able to do. Also, I'm not an attorney, so nothing I say could be construed as legal advice. I am not practicing law without a license or anything like that, which is another reason I've tried to stay away from that topic. But recently I had a discussion with a viewer about a general topic that I'll cover in the course of this video, and I thought maybe I could at least give a little bit of perspective on this to try to help folks out, because there are certain topics that are constantly hashed over in gun shops and at gun shows and even outside of the firearms world, different places that people will discuss certain topics. And it seems like there are very strong opinions one way or the other on some of these. And I just want to weigh in a little bit with what I think on some of these topics. I'm actually going to talk about three things during the course of this video. One of them is the use of hand-loaded or reloaded ammunition in a defensive shooting. The next is going to be using expensive firearms and equipment as opposed to lesser expensive firearms and equipment if you're involved in a defensive shooting. And the last one is going to be making any sort of modifications to your firearm as opposed to the condition it was in when it left the factory. So I'm going to dive right into this, and by the time we get done, maybe I'll at least be able to give you a little bit of food for thought. So a couple of things I want to cover right here at the beginning. First of all, as I said a few minutes ago, these are just my opinions on these matters. I am not trying to give anyone legal advice. I'm not trying to tell you how things are where you live or tell you what you should do. These are just my opinions on these matters. But they're my opinions based on a 3.5-decade career in law enforcement, during which I spent a lot of time involved in criminal proceedings. I spent some time involved in civil proceedings, and I've studied both criminal and civil proceedings extensively with regard to use of force by police officers and defensive use of force by non-police officers. So I just want to throw that out there at the beginning. Also, when I say liability, I'm going to be using the word liability as a general term to encompass both criminal liability and civil liability. Now, with a criminal case, the government at some level, federal, state, local, has decided that a certain person has committed a crime, or at least there is good reason to believe that person has committed a crime, and an attorney representing the government is going to attempt to present to the court evidence to prove that person is guilty of a crime beyond a reasonable doubt. So when we talk about criminal liability, it is with the idea that someone has been charged criminally and there is going to be a prosecution of that person to determine whether or not they are in fact guilty of a crime. On the civil side, with civil litigation, this is an instance where someone is suing another individual for injuries or damages resulting from some action that that individual took or should have taken or didn't take. In that type of a proceeding, a plaintiff's attorney is going to attempt to prove to the trier of fact, either the judge or jury, that the defendant acted in such a way as to cause the injury or damages or what have you to the plaintiff. And if the attorney is able to prove that by a preponderance of the evidence, then the person will be held liable for whatever damages, and then it's up to the court to determine what those damages are going to be. I want to draw a distinction between the two burdens of proof. As I said, in a criminal case, someone has to be proven guilty beyond a reasonable doubt. That's a fairly high burden of proof in the legal world. On the civil side, someone only has to be held liable by a preponderance of the evidence. So if there's 51% of the evidence saying that the person is liable and 49% saying they're not, then the person, at least by pure legal terms, should be held liable. So that's a much lower burden of proof and a much lower legal standard. Now, an individual can be charged criminally and sued civilly out of the exact same incident. So keep that in mind too. And people can be found not guilty criminally because of the higher burden of proof, but held liable civilly because of the lower burden of proof out of that exact same incident. Now, one other thing that I want to cover. Beware the individuals out there who want to speak in absolutes. Remember Star Wars, only a Sith speaks in absolutes. With someone who wants to tell you, if you do this or that, you're definitely going to be held liable, or if you do this or that, you're definitely not going to be held liable, is demonstrating a very poor understanding of our legal system. When someone makes a statement like that this or that is going to cause someone to be held liable or cause someone to be exonerated, it's kind of like trying to predict the weather on a certain day at a certain time, months or years into the future. That's kind of the same ballpark because there are so many variables and so many circumstances and so many other factors that come into play that it's virtually impossible to do that. Each case is unique in and unto itself, which is why each case, as it's litigated, eventually has the facts presented to a trier of fact to make a determination on the facts of that case. So I hope that all makes sense. I hope I didn't lose anybody in that, but that's where I'm coming from as I start into this discussion. Okay, there's one last distinction I want to draw before I move on, and that is the fact that in either a criminal case or a civil case, the burden of proof is not on the defendant. The defendant doesn't have to prove they're not liable or not guilty of a crime. It is up to the state in a criminal case to prove that the defendant is guilty beyond a reasonable doubt, or in a civil case, it is up to the plaintiff's attorney to prove that the defendant is liable by a preponderance of the evidence. The defendant does not have to prove that they are not liable or not guilty. Now, there are times that the burden of proof can shift to the defendant. For example, here in Ohio, if someone is charged with, say, murder, and they put forth an affirmative defense of self-defense, then the burden of proof shifts to the defendant to prove that by a preponderance of the evidence, their actions were an act of self-defense. So there are times that it can shift back and forth, but ultimately the prosecutor or the attorney representing the government in a criminal case or a plaintiff's attorney in a civil case have the burden of proof, and they have to prove the defendant is either guilty or liable. So here we go, hand-loaded ammunition. This is discussed all the time. It has been discussed for years and years and years and years, and you hear people, on one side say if you use hand-loaded ammunition, if you ever go to court, you're just done for, you don't have a prayer, you're going to be held liable, convicted of a crime, whatever. You hear people on the other side say, nope, that doesn't make any difference. You should be able to use whatever kind of ammunition you want to, and there's never going to be a problem. Now, if you ask an attorney, and this is going to apply to anything that I'm going to say, the attorney is always going to say, don't do it, because don't do it is safe. Don't do it maintains the status quo. If nothing bad is happening to you right now, then right now is considered to be safe. I want you to understand that. Attorneys try to imagine a worst case scenario and they try to keep their clients out of trouble. So the attorney is always going to recommend, if there is a choice like that that comes up, either use hand-loaded ammunition or don't use hand-loaded ammunition. The attorney is always going to say, don't do that, because that's one less variable they have to deal with eventually someday if they end up representing that individual in court. Again, I hope that makes sense. And by the way, that's going to apply to the other topics that I discuss as well. If you ask an attorney is always going to say don't do that because they are trying to minimize any potential liability. Now, as I said, you cannot deal with this topic in absolutes. If, for example, we have a hypothetical individual who is carrying a firearm for defensive purposes, and that person is using hand-loaded ammunition that is hand-loaded with conventional bullets that are loaded to standard pressures, just like factory ammunition, and for all intents and purposes, it performs just like factory ammunition. And that person is involved in a defensive shooting, and that person shoots another individual under circumstances that are absolutely justifiable. I want to make sure that's understood. I'm not talking about somebody who does something questionable, and then the idea that they used hand-loaded ammunition is introduced into there as well. I'm talking about the police investigate the case, they determine that it's an act of self-defense, everybody looks at it, everyone agrees that this person has defended themselves in this instant. In that situation, I don't think the fact that they used hand-loaded ammunition is going to have any bearing on the case at all, because the person's actions were perfectly justifiable. Again, the ammunition performed properly, it did what it was supposed to do, everyone is in agreement that it was a justifiable act, so I don't see how possibly the use of hand-loaded ammunition becomes a factor in that case. Now, if we have that same person, and let's say in this instance, the person is using hand-loaded ammunition that they've loaded up a little warmer than the factory ammunition normally is, and they're using super duper XYZ PDQ bullets that in all the marketing for those bullets, the factory that manufactures them talk about they are the most lethal bullet on the market. This is the bullet you need to have. It's going to kill them good and dead. It's going to kill them deader than anything else. And that person is involved in a defensive shooting. And particularly if now it's a little bit more murky when it comes to the justifiability of the person's actions, and they shoot someone and that person dies. Just the bullet hits them, that XYZ PDQ does what it's supposed to do, and that person just is dead, just like that. Hits the ground, and maybe it's a shot in the arm or something like that. And maybe later on there are medical experts that say that, but for the use of the XYZ PDQ bullet, this would have been a survivable wound. But because that bullet was used, this person was done for and whatever. And that the decedent's surviving family members decide to turn around and sue the person who fired the shot for wrongful death or what have you, then I could see where that might become a factor. If they're talking about this was beyond what would have been necessary to stop that individual from whatever it was that they were trying to do, I can see where maybe there would be an argument there. Now, would the person ultimately be held liable because of that? Again, there's no way to predict that. It's just too dependent on the specific facts of the incident to try to predict what a judge or jury at some point in the future is going to think about that person's actions or their use of hand-loaded ammunition or what have you. Now, scenario number 3. The person uses the XYZ PDQ bullet with all the things that I talked about before, but they're loading that just as hot as they can get it. In fact, they've loaded it up to the point where that bullet is achieving the speed of light. In fact, the bullet is inflicting a wound on the person being shot before it ever leaves the barrel of the firearm that's being fired at the bad guy. That's how fast it's moving. And in this instance, the bullet travels completely through the bad guy, across the street, and strikes a child on a school playground that's somewhere back behind. And that child's family now turns around and sues the individual who fired the shot, or potentially a prosecutor looks at that and determines that there is some criminal liability resulting from the person's actions. I would start to feel a little nervous in that case, with a situation where particularly you harmed someone who you didn't even intend to harm, and it's somehow related to or potentially related to that ammunition that you hand-loaded yourself. I would feel a little nervous. Now, I'm not going to say that the person would absolutely positively be held liable or be convicted of a crime or anything else. Again, that's dependent on too many specific facts and circumstances of that case. But I would feel uneasy. I would probably feel very uneasy if that was me. And I'd feel horrible that I injured someone that I never wanted to injure in the first place. It was completely innocent. And I would feel very uneasy when it came to the legal proceedings coming from that incident as to how that was all going to play out in court. Okay, on to door number 2. And this is the idea that someone might be using a less expensive firearm or less expensive equipment as opposed to using more expensive equipment or firearms in a defensive setting. Now, this is a situation that I actually had a long semi-argument / discussion with another law enforcement sniper years ago. This sniper worked for a large department that had a lot of money, And this particular individual, his department had purchased very, very expensive equipment, expensive rifle. It was one of the most expensive rifles that was manufactured for police tactical use at the time, an extremely expensive scope, and all of the equipment this individual had was absolute top of the line. And he was talking about how the use of that equipment was lowering his liability and his department's liability. And I took a little bit of an issue with that, and I'm going to keep this in the law enforcement realm, but these same dynamics are going to apply if you have someone who's not a law enforcement officer that has the same type of situation, a less expensive firearm and equipment as opposed to more expensive. Now, I'm not discussing quality here. I'm not saying that the less expensive items are of the same quality or have the same capabilities or what have you as the more expensive equipment. I'm talking about just the idea that more money was spent in a certain allocation of firearms or optics or what have you, as opposed to less money being spent. And I think there are some people also that are not police officers who have this idea that if they ever find themselves in a situation where they've had to shoot to defend themselves, they can say, look at how much money I spent on all my equipment, so everything should be okay. And that a plaintiff's attorney or a prosecutor is going to go, well, yeah, you exceeded the liability threshold there, so with your purchasing, so doggone, I guess we'll have to try something different with the next guy. That's not what's going to matter. What's going to matter is what resulted from the use of that equipment. Again, I'm going to keep this in the law enforcement realm, but bear with me here because, again, I think a lot of what I'm going to say is going to be applicable. Let's say we have law enforcement sniper number one who has an old, pick the big box store that still sells firearms, a bolt action rifle. It's nothing special. It's the entry level rifle for that particular manufacturer. When they bought the rifle, they looked down in the glass case there, and there was a scope down there for $69.99, a very inexpensive optic that they mounted to that rifle. And that's what they're going to use for a sniper system. Now, most law enforcement officers, particularly SWAT team snipers, are going to hear that and they're going to think, no, nobody in their right mind would ever do that. And I agree, but hypothetically, we're going to say that's what this individual did. We're representing the absolute least amount of money that could be spent on this firearm and equipment, and even the ammunition is going to be whatever the lowest bulk pack ammunition is that they could find for this particular rifle, and that's what they're going to use to deploy with. And the sniper finds themselves in a situation where they have had to deploy with this system, and they actually have to engage a bad guy. The circumstances are such that they are going to have to fire to defend an innocent person, and the sniper takes the shot, and it is a perfect shot. The bad guy is stopped, just like our scenario a little while ago. It's absolutely justifiable. In the after-action investigation, it's determined that the sniper's actions were 100% justifiable. There is nobody injured who should not have been injured, and again, the sniper using that system placed the shot perfectly, and everything happened the way it should have. The idea that the sniper is going to incur some liability now because they used an inexpensive rifle and optic and ammunition and what have you in that instance is silly. No, that everything happened the way it was supposed to. It would not have made any difference if more money had been spent because the actions of that sniper were perfectly justifiable and the results were exactly what they should have been. So that's scenario number one. In that instance, I cannot see any liability being imparted to the sniper's agency or what have you, because they didn't spend a lot of money on that particular system. Scenario number two. This time we'll say our sniper works for a department that has a little bit more money and they purchase a middle-of-the-road rifle. Yeah, something that it's not the absolute most expensive thing out there, but it's a decent rifle capable of decent ammunition, but maybe they skimp on the optic. Maybe they choose a lesser expensive optic. And sniper number two finds themselves in that same situation where they have to take a shot, and maybe in this instance they fire the shot and the shot's off a little bit. It doesn't strike exactly where it should. And rather than dropping the bad guy just like that, the bad guy is mobile for a little bit of time and manages to fire a shot and injure a hostage, or maybe more than one hostage. So now in the aftermath of that, and the investigation is conducted, it's determined that the optic used on that rifle doesn't maintain a good zero, and had the department chosen a better optic that would hold zero, the sniper's shot potentially would have been better and the bad guy would not have had an opportunity to fire and injure any of the hostages. That's a situation where I could see the argument being made. I could understand that. Again, if our sniper in scenario number 2 has a shot that's right on the money and there's no issues, nobody that was not supposed to be injured is injured, then I don't think there's any liability there. But if someone is injured that should not have been, I can see maybe. I'm not saying absolutely, I'm saying maybe. So now let's move on to our sniper that works for a large organization that has a lot of money, and they buy a system that all snipers dream about. It is an absolutely top-of-the-line rifle, top-of-the-line optic, the best ammunition that is loaded by any manufacturer out there anywhere. That sniper is in this situation, and that sniper has to fire a shot, and the sniper just has a flat-out miss. It's just a bad shot. And in fact, the sniper hits a hostage. In the aftermath of that situation, the fact that there was so much money spent on that rifle and optic and ammunition and what have you, I don't think is going to be sufficient to absolve the sniper or the sniper's agency or what have you of liability because of what happened. And again, I'm not trying to predict with absolutes and say this is how things would turn out or wouldn't turn out or anything else. But if I'm that sniper, the fact that I've got more money that has been invested in my equipment than my house cost, I don't think is going to make me feel a lot more secure when the criminal and civil proceedings come around. And on to the last topic. And this time I'm going to talk about the idea of making any modifications to a firearm from the way that it was when it left the factory after being initially manufactured. And again, you'll hear people go back and forth on this. A lot of police departments, in fact, virtually every police department, has a policy that prohibits officers from making any modifications to their firearms. The only people that are allowed to do anything beyond routine cleaning have to be trained armorers. But how is that going to apply if you have someone who actually uses a modified firearm in a defensive encounter? Well, again, I'm going to have 3 different scenarios. Let's say in scenario number 1, we've got a wheel gunner. We've got an old-time wheel gunner that likes his revolvers, and when he gets his revolvers, he goes ahead and does just a little bit of stoning. He smooths the action a little bit. Nothing major, just to make it a really good feeling revolver action. The trigger's not really any lighter, it's just good and smooth. And that individual finds themselves in a situation where they have to use their revolver to defend themselves. And they deploy the revolver, and again, this is an absolutely justifiable situation. We'll say this is someone that's approaching with a knife saying, I'm gonna kill you, you know, whatever, never liked you, I'm gonna kill you. The person is relatively close. The defensive shooter produces the revolver, perfect double tap, the bad guy goes down. There's all kinds of witnesses that are talking about how the individual fired to defend himself, that he was being approached by this guy with a knife. The guy with the knife was saying, I'm going to kill you, etc., etc., etc. And in the aftermath of the shooting, it's determined that our defensive shooter was absolutely justified in his actions. Again, just like with the hand-loaded ammunition, in that circumstance, I can't see how the fact that this individual did a little bit of trigger work on their revolver to make it a little bit more shootable is going to have any bearing whatsoever on the outcome of either a criminal or civil proceeding. I can't see how that would ever become a factor. But let's change things a little bit. Let's move on to shooter number 2. And we'll say this is somebody... We'll say this is a 1911 shooter, 1911 aficionado. And the 1911 aficionado is using a 1911 with a match trigger, and they've got all kinds of work that's been done on this. It's got a beautiful break, on the range. This is a person that can just stack bullet on top of bullet on top of bullet, but it's a light trigger, or at least lighter than it would have been when it left the factory. And we'll say shooter number 2 is in a situation where, once again, our bad guy has a knife, but now let's say the distance is greater. Let's say the bad guy is something like 10 yards, 15 yards away, something like that, and has produced a knife, and our defensive shooter decides to go ahead and draw their 1911, and in the course of doing that, they accidentally get a finger as they're trying to take the safety off or what have you, get a finger inside the trigger guard and crank off a round, and it hits the bad guy in the leg. So the bad guy's not killed, but the bad guy is injured. But because of the distance involved, later on, prosecutors or plaintiff's attorneys decide that at the point the shot was fired, the defensive shooter wasn't really in danger yet. That's a situation where I could see the argument being made that because of the modification to the trigger that was done by the shooter, there was a situation where the round was fired before the shooter was ready to fire, and the shooter is responsible for making the modifications to the firearm. Again, I'm not saying absolutely that shooter is going to be held liable or convicted of a criminal violation, but I would feel uneasy in that circumstance. So again, we see how where there are different distinctions based on the level of modifications and the exact circumstances that result from the use of that modified firearm. So now let's go on to shooter number 3. Shooter number 3 has a race gun. Doesn't matter what kind of race gun. And shooter number 3 has a trigger in there that if you blow on it, the trigger goes and the action fires. And shooter number 3 is in a situation where our bad guy with the knife is presenting a threat, and shooter number 3 draws the firearm, and in the course of doing that, gets a finger inside the trigger, cranks off a round, misses the bad guy, and strikes an unintended person. Or maybe the bad guy is at a greater distance again, and shooter number 3 comes around and manages to crank off a round. It's a dead center shot. The bad guy is dead right there. And again, in the aftermath of that shooting, it's determined that at the point the shot was fired, there was not yet an imminent threat that was being faced by the defensive shooter. That's a situation where I could see that modified firearm becoming a factor in the ultimate litigation of that case, and it could present big problems for a defensive shooter. So again, trying to speak about any of these, whether it's hand-loaded ammunition, the amount of money you spend on a firearm, or making modifications to the firearm with any sort of absolute certainty is impossible. It's all based, the outcome of the case will be based on the specific facts and circumstances of that case. There's no way to predict the future. But although we can't predict the future, we can look at what has happened in the past and try to draw some inferences. And the way that's commonly done is by looking at case law and examining what has happened in actual defensive shootings. And what I'll say is, with all of these circumstances, whether it's hand-loaded ammunition or the amount of money that was spent on a firearm and equipment or modified firearms of one type or another, I've never heard of a case that has turned on that specific circumstance. A case where but for hand-loaded ammunition or but for the use of a inexpensive firearm or equipment or but for the modification to a firearm that an individual would otherwise have been found not guilty or not been held liable, but because of that one thing, the individual was found guilty of a criminal violation or was held liable civilly. I've never heard of that. And if you're aware of a case where, but for that one, now don't send me a case that's got all kinds of other facts and everything else in it, and that was just one thing that was mentioned by a plaintiff's attorney or a prosecutor or what have you. Because who knows what was the most significant factor to the jurors or the judge or what have you in that type of a case. I'm talking about a case where everything else was fine, everything else was justifiable, but that one issue is the one that caused the person to be convicted of a crime or to be held liable. If you're aware of something like that, I'd like to hear about it. So there you go, folks. That's my thoughts on liability issues as they relate to the defensive use of firearms. I'd like to hear yours. If you have any questions or comments, as always, make sure you forward those to me. Remember, if you purchase anything from Optics Planet, be sure to use my discount code, which is... Also, remember, if you purchase anything from warbirdbunker.com, they are producing t-shirts for the channel. And if you go to warbirdbunker.com, you can find my t-shirts there, as well as all of Nathan's other firearms and patriotic themed gear. And if you use my discount code there, that'll save you 10% off your purchase from warbirdbunker.com. And also, we have a new discount code, and this is from House of Pain Munitions. And I've got an upcoming video talking about House of Pain Munitions, but if you go to House of Pain Munitions and you use my discount code here, that will save you 10% on your purchase from House of Pain Munitions. So thanks to them for that new discount code. And that's going to do it for now, folks. Until next time, hopefully liability-free, good shooting. Bye-bye.